As noted in Section 20, where we went over the different clauses that can appear in an ocean carrier service contract, in Section 21, where we are now, we're going to go into an actual contract. Let's jump right in. The first thing that we'll say about this contract is that we're actually looking at page 2 of the contract terms and conditions. Because it is an actual contract between a steamship line and a beneficial cargo owner, we left out page 1 because it's all of the proprietary information about who those parties are. We want to respect the anonymity of the parties, but we will reiterate that this is an actual contract between a medium-sized BCO and a steamship line. We will start with terms and conditions that actually run in the same sequence as what we saw in Section 20. Let's begin with number 1, the governing tariffs. And to the best of our ability, we're going to try to avoid reading word for word. It will just become too boring. We want to point out the most salient points without going through it word for word for word. With that said, governing tariffs, what does that mean? Basically, the rates that appear in the contract, especially in Appendix A, which we will be looking at, are the rates that apply. Another important point, last sentence, in Clause 1, cargo moving under this contract is also subject to the terms and conditions of the carrier's bill of lading. That's the reverse side of the bill of lading, where a lot of liability limitations are listed by the carrier. Let's point out now that it's important to not only understand the terms of a contract, a service contract with a carrier, but what the back of a bill of lading actually says. Number 2, we can run through this fairly quickly, shipper and affiliates clause. Basically, that says whosever name appears in the contract, that's who the contract is with, in addition to any listed affiliates, divisions of a company, for example. But also that whoever signs the contract has the authority to enter into the contract, an important legal consideration. And then finally, the shipper or the affiliates listed herein must appear as the shipper or consignee on the bill of lading. That paper trail that is born of the ocean carrier contract in this instance must be consistent with the contract, meaning that whoever signs the contract, that's whose name has to appear on the bill of lading. Number 3, minimum quantity commitment. This is where the different container sizes are accounted for in a single unit of measure. In this case, TEU, 20-foot equivalency unit. This clause recognizes that BCOs will use different sizes of equipment, maybe a 20-footer, maybe a 45-foot high cube. This allows the parties to measure in TEU or FEU all of the equipment used. We'll note a couple of them. A 20-foot container shall equal 0.5 FEU. That makes sense. A 20-footer is considered a half of a 40-footer. A 40-foot standard container, 8 foot 6 inches high, shall equal 1 FEU. Well, that makes even more sense. And we can move down quickly and see the other equivalencies. At the bottom, a 40-foot, 9 foot 6 container, that's a 40-foot high cube, shall equal 1.125 FEU, and a 45-footer shall equal 1.25 FEU. Number 4, contract rates. Really what this is saying is that all the rates are found in Appendix A, which we will look at in a moment, what are mutually agreed upon between the parties. However, if we look at B, the surcharges, additional charges clause, an important one, and it carries on to the next page, we'll see it in just a second. Except as otherwise provided in Appendix A, all charges, surcharges, CAF, BAF, war premium, etc., continuing on at the top of the page, arbitraries, origin, destination, delivery charges, on and on and on, in effect at the time of shipment shall be assessed in full hereunder. This little clause should jump right off of the page, because it's a reminder of what we've been saying all along. You have your base ocean freight rate, the CY to CY rates, for example, but there may be lots and lots of accessorials that when added together actually are more than what the base ocean freight was. As a BCO, we need to pay attention to that. Number 5, service commitment, what is referred to as a non-performance clause. This is from the carrier perspective, and we can see that right away. During the terms of this contract, the carrier will provide vessel space sufficient to carry the minimum quantity commitment. That should be very easy to understand, because in a contract where a BCO commits to, say, 1,000 TEU or 2,000 TEU, the carrier has to provide the equipment and the space to accommodate that. That's what they're talking about here. But in B, let's read this. Should the carrier fail to provide space sufficient to carry the MQC, the shipper's remedy shall be set out as forth in Clause 8B. We'll get to Clause 8B in a second, and it does not favor the BCO. More on that in just a second. Here's another important one, C. The shipper agrees to give 14 days booking notice, if possible, but not less than 7 days. That hopefully electronic booking, made by the U.S. importer's vendor overseas, it's a contractual thing. At the very least, 7 days in advance. Vendors overseas need to know that. And then D, where the carrier slips in another one, booking acceptance is subject to equipment availability. Well, what happens if there's no equipment is a big question, and something that must be taken into serious consideration. Number 6, verification of contract carrying and record retention. The most important thing here is the second sentence. Bill of lading documents provided to the carrier must indicate the correct contract number. Each original BL moving under this contract will show the contract number. That's so the carrier knows to rate the proper bills associated with the contract. A seemingly small detail that's really quite important. 7, confidentiality. Like any confidentiality clause, the two parties agree not to tell anyone else about it. However, second paragraph, to the extent required, either party may disclose confidential information to an ocean freight forwarder or customs broker. Of course, forwarders and brokers need the information on a bill of lading to do lots of things, one of them being export clearance at origin, another being customs clearance at destination. At the very bottom of this slide, we'll notice a dead freight clause that actually carries over to the next page. It's pretty important stuff. The dead freight clause is the BCO's responsibility to meet the minimum quantity commitment and what happens if they don't. A situation where a BCO signs up for 5,000 TEU and in the course of the contract period they only tender 4,000 TEU. That's a dead freight occurrence. What happens when that occurs? Right at the top, under A, if the shipper fails to tender the MQC specified in Appendix A, the shipper agrees to pay what's called a deficit charge on the difference between the quantity shipped and the MQC. In this instance, at $250 per FEU. That is a dead freight clause, sometimes referred to as a shortfall penalty. In B, and we spoke of this a moment ago, where we were looking at things from the carrier's responsibility perspective, and they mentioned reference 8B. If the carrier fails to fulfill its service commitment in Clause 5 that we just spoke about, the shipper's sole remedy options shall be reduction of the minimum quantity commitment by the quantity of cargo not carried by the carrier. That's pretty convenient for an ocean carrier to say, well, yeah, we signed up for 2,000 TEU, but we can only move 1,500, so your MQC goes down to 1,500. That really doesn't help the BCO very much, because what about the 500 they couldn't move? That's an important clause to negotiate as well. 9, audit and record retention. Just the rules around keeping originals of the contract pursuant to maintaining records and conducting audits in accordance with the requirements of the FMC and the Shipping Act of 1984. Applicable law, very common in any type of contract, stating in this case that U.S. law and the Shipping Act of 1984 apply, and that any arbitration shall be by an arbitrator appointed by the New York Society of Maritime Arbitrators. Hopefully it never comes to that in a contract, but any contract is going to have an applicable law clause. Number 11, entire contract. This basically says that the content of this 10, 11-page document, that's the contract. Nothing outside of it really counts. Number 12, assignment clause. As we see at the top of the next page, that just means that the shipper may not assign or transfer the contract to another party. Cancellation and termination. The important thing here being that the contract can be canceled or terminated by the mutual consent of the parties in writing, but also, we'll note in B, Roman numerals 1 and 2, the carrier has the right to terminate the contract under certain conditions if a shipper becomes insolvent. if the shipper files a petition for bankruptcy, those types of things. 14. This is a little bit cloudy, a little bit confusing, but it's easy to clarify. The exception clause. And this makes reference back to the reverse side of the bill of lading that we spoke of previously, specifically clauses 7, 9, 18, and 29. Really what this is saying, without reading into too much legalese, is that if cargo or any part thereof that was legal to ship when delivered to the carrier becomes unlawful or illegal after goods are shipped, any expense related to the recovery of those containers is not going to be on the steamship line. Well, what does that mean? A quick example, an exporter of frozen chicken to Russia, and this is a real case, by the way. An exporter of frozen chicken to Russia ships 15 reefer containers on the first of a given month, and 3 days into the month, the U.S. puts sanctions on Russia, and no more frozen chicken or frozen anything for that matter can be shipped to Russia. That's where something like this would apply. It's on the shipper to make sure that that stuff doesn't get to Russia, and all costs associated with getting those containers back is on the shipper. Sounds a little obscure, but it actually happens. Number 15, cost relating to service contingency. Really, what this is talking about, it picks up in the second line, shipper shall be subject to any rule in the governing tariff establishing a charge relating to any of the following circumstances or charges arising. Containers are tendered to a steamship line, and something like a strike, a lockout, a work stoppage, labor unrest happens, and there are expenses incurred as a result of those activities. All of those expenses per this clause are on the shipper. 16, shipper party liability. Basically states that the shippers and the parties listed in Appendix B, which is essentially in this case the BCO, is jointly and severally liable for performance of undertakings and in particular the payment of all rates. Basically what this is saying is whoever's name is on the contract, that's who has to pay the rates, that's who has to pay additional charges, and if there's any disputes or liabilities that arise from anything related to the contract, whoever is on the contract, that's who has to pay. Let's look at force majeure. It's a long clause and an important one because it talks about circumstances outside the control of the parties that prevent one or both of the parties from performing their obligations. Force majeure means acts of God. And when one thinks of acts of God, one might think about a tsunami or a volcano that erupts near a port, things of this nature. And that is indeed true. But force majeure also includes, as we see, work stoppages, strikes, industrial slowdowns, very human things as well. And really, force majeure, when enacted, removes the liability from one or both of the parties from performing their contractual obligations. However, the parties shall take all reasonable measures to remove the effect of the force majeure condition. And this particular clause talks of notifying the parties within 14 days of such circumstances occurring, taking measures to alleviate those circumstances, and at the bottom of the first paragraph, in the event that such force majeure conditions persist, for 15 days, the affected parties are excused from their obligations. As we can see, force majeure, pretty critical stuff. 18, the chassis clause. This is really important in the United States because up to, call it 8, 9, 10 years ago, the steamship lines would provide chassis to importers, the chassis being the framed wheeled unit upon which containers are placed and moved around for drayage purposes. These days, the steamship lines don't provide chassis. And what Clause 18 is saying is, we as the steamship line do not provide chassis. That is up to the BCO and the drayage arrangements that they can make. We're almost finished here. We're getting into Appendix A that we've alluded to this service contract. Again, we took out the carrier and the shipper, the contract number, but one more time, this is an actual contract. Duration, May 1, 17 to April 30th. That's not unusual. Most contracts for ocean services, at least in the United States, coming out of Asia, are negotiated right around that March timeframe. Contracts go into effect the April timeframe. We took out the description of the commodities, again for anonymity purposes, but they have to be listed here, wearing apparel, footwear, whatever the case may be. Here's the minimum quantity commitment expressed in TEU. There's 1,000 here. That's what this service contract is for. Down the bottom, we see origin countries and areas, which, as we'll see in the next page, becomes more refined into port pairs. But we will note China, Hong Kong, Indonesia, a couple of other countries there. We have our destination country, United States, needless to say. Contract rate in US dollars. It's always important to have the currency listed clearly. In general, we're talking about the Far East to the USA. We have our commodity in Group A. Again, it was blanked out here. But now we can see the port pairs. Let's go down the list. Origins like Hong Kong, Singapore, Thailand, Taiwan, Vietnam, all going to LA Long Beach. Moving to the right, this is where the rates would be listed. Once again, they were there. We blanked them out for a 20-footer, 40 high cube, and a 45-footer. Down the bottom, some important notes to be aware of, bearing in mind that this contract is for containers going through the ports of LA Long Beach. They could be different. The notes could be different if goods were going through Philadelphia, Norfolk, Miami, Houston, wherever. For example, note S1. Rates are inclusive of the Alameda Corridor charge, currency adjustment factor, destination delivery charge, and peak season surcharge. There's reference to PSS, which is basically saying that these rates include any peak season surcharge. That's really, really important. Note A1, free time for equipment at LA Long Beach Port, 15 working days. However, another important one, this provision is not applicable to shipments moving in non-active reefer containers, but here's the important one for us, 45-footers. What they're saying here is that 15 free days doesn't apply to 45-footers. We need to know that and agree to that as the BCO. Another note, an important one, rates in Appendix A of this contract are not subject to any general rate increase. Here, we're capturing what we talked about in previous sections. PSS clause, GRI clause. The important proviso to make here is, let's see if this sticks. Because out in the real world, we said this previously, an ocean carrier could say, yeah, we'll honor the contract, but your containers aren't going to move. Or we're not even going to give you equipment. That's the reality of dealing with ocean contracts. We have to pay a lot of attention to that as the BCO. All right, that wraps up the conversation on an example of an ocean service contract between a steamship line and a BCO. When we come back, we'll be talking about advantages of negotiating contracts with an NVOCC. It's a different ballgame working with a steamship line versus a non-vessel operating common carrier. That's what we're going to cover in the next section.